Wayne and Jess for breakfast. We are joined with our Radio 97 lawyer, being a Thursday, Despina Priala. And you can tell us about a recent ruling when it came to a phone and a PIN when a police officer asked to have those details and someone refused.
That's exactly right. So it's a recent case decided in the Court of Appeal in Queensland, and it's a case of the Commissioner of Police in Barbaro. That's the name of the case. So the decision was handed down last week on the 27th of October, so it's very hot off the press. Yes.
Can you give us the details? It was on the Gold Coast?
It was on the Gold Coast. So the police had actually issued a search warrant for this particular person at his premises. So when they were going through his house, they found a mobile phone. And they said to Mr. Barbaro, could you please give us the PIN so we can unlock this phone, because we want to have the phone and see the information that's contained within the phone. And he said, no, you cannot have my PIN. There is legal, professional, privileged information and confidential information contained within my phone. You're not getting the PIN. So the police charged him with disobeying a lawful direction, which is allowed under the Queensland Criminal Code.
Oh, so usually I thought you might be able to refuse, like a no comment situation, but ordinarily before this case, if you had said no, you still have to follow orders and open up the phone?
Well, it's interesting you say that and you mention it, because in the particular act under the Queensland Criminal Code, unless you have a lawful excuse, and we have to define what lawful excuses in this case now actually does, or it gives a big insight into what could be considered a lawful excuse to refuse. So unless you have a lawful excuse, you have to comply with a lawful direction given by a court or a person authorised, such as a police officer. And if you refuse to obey a lawful direction, you can actually be charged with a misdemeanour, and if you're found guilty of that misdemeanour, it's 1 year imprisonment.
So was this gentleman actually charged with that, a misdemeanour?
He was. He actually contested it, because they continued to say, you must hand over the PIN. And he said, absolutely not. What is in my phone is confidential. There's information on my phone about meetings, file notes, text messages between myself and my lawyer. That is covered under legal, professional, privileged. And the Queensland Police fought it, because they said, well, you're wrong and we need that information. So we need your PIN to get into the phone.
And it's quite true these days, of course, our phones tend to be our life. They tend to hold all sorts of information, private information, as you say, videos, PIN numbers, all sorts of
bank
things.
Details.
Bank details, etc. So just not to mention telephone numbers, of course. So if someone was to get into that phone, basically they could have access to pretty much all of your private personal information.
Access to who you are.
Confidential information, yeah.
That's exactly right, and that's what Mr. Barbaro was arguing, particularly when the Queensland Police did not qualify the request. So they simply said, give us your PIN to unlock the phone. That's it, general request. Yeah. So they didn't ask for it to be qualified. They didn't say, well, we want the PIN to access the phone because we want to have this particular item in your phone. So it was a blanket, give me the PIN. And once you give someone your PIN, you unlock your phone. Once your phone is unlocked, of course, then you have free reign, unlock your life. Everything, text messages, as you said before. He could have had videos of meetings. He could have had audio recordings of meetings. He could have had notes in there, which he claimed he did, that was covered under legal professional privilege. So it started off in the Magistrates Court, and it went all the way up to the Court of Appeal to get this decision. So we know that it's a very superior court that has made this decision, and in the future people will be able to look to this if they're in a similar situation that this particular person found himself in. So in the end, the court agreed with Mr. Barbaro that he had a lawful excuse not to provide the PIN to the Queensland Police.
All right, so there could be a precedent right there.
It's absolutely a precedent, and particularly because, as I said, it started off in the Magistrates Court and the Queensland Police won, and the particular person involved took it to the District Court, and then he won in the District Court, and the Queensland Police then appealed it. Okay, and said, no, we're going to appeal this, because this is quite significant when you think about it. it's actually, when you said before, it's going to set a precedent. Queensland Police obviously pushed for this to have the appeal, because it's going to, if they won, it would have opened the floodgates, I dare say, for them to, with their search warrants, to be able to get all and sundry for their search warrants, including information on phones, because they're saying, well, unlock the PIN. If this case was decided in their favour, then anyone in this circumstance would be required to hand over their PIN on their phones. And as you said before, Wayne, it's very true. These days, fortunately or unfortunately, we do live by our phones.
True.
Everything is contained in our mobile phone. Our whole life history, meetings, personal relationships, business relationships, pictures, videos. You can imagine if you open up that, and the floodgates would have opened up to the Queensland Police.
And we're talking particularly here about Queensland. So this is Queensland only. The law may be different in New South Wales?
It may be different. I haven't looked into it because this is just a recent case.
Yep.
So I'll try to do that for the listeners for New South Wales to see if there's something similar. But I dare say there would be. Queensland Criminal Code has been around a very long time. It's been amended many, many times. And the Queensland Police have very far and wide-reaching powers. And this is another example where, yes, they have discretionary powers and they have wide powers, but in this case, not quite so when it comes to a request for a PIN on your mobile phone under a search warrant. Now, this particular search warrant and request, as I understand, was a general request. So the request was, give me your PIN to unlock your phone, period. It wasn't qualified. It wasn't, well, we want it for this particular purpose.
Had they have specified that, it may have been a different outcome?
I think it might have been a different outcome, and I think the Queensland Police will actually take this case away and go, well, we didn't win on that point, so maybe in the future they're going to get advice and look into particularising requests under search warrants for mobile phones. So a search warrant, you come into your premises, if the search warrant's been validated, they're allowed to go in and search your premises, okay? And they found the phone, as I said before, could have been a laptop as well, that have passwords and pins on your laptop. That's right. So this particular case could extend to those other electronic devices, so that's important to mention as well. So it is a significant case, but as we said before, if it was qualified, it might have had a different outcome, but that's the law, isn't it? So
it is, and these things through various case law and whatever over a period of time will change and will alter and whatever. So that's interesting that this is pretty much hot off the press. It's only been in the last couple of weeks. So.
It's only was last week. So yes, hot off the press.
Yep.
So people can take this away, and it is a decision made by a superior court in Queensland.
Great to hear that. So at current, before it's amended again, we know that we don't give our PIN over if it's asked without any specified reason.
That's exactly right.
All right, well, that's it for the program. We've run out of time, unfortunately, ladies. We will do it again next week. Now, just a reminder, if you do have a question that you would like Despina to answer for you, we're happy to present it to her here on a Thursday morning. All you need to do is send an email to breakfast@radio97.com.au and just give us a couple of details about the issue that you're looking at. Doesn't really matter what it is. We're happy to present it, and Despina will answer it for you. It's breakfast@radio97.com.au.
And your boutique law firm is found up in Runaway Bay?
Yes, it is, in Cockleshell Court, Runaway Bay, and phone number 55291 294.
And otherwise, prialalegal.com.au. We can find you online too.
Yes.
I'll just put a bit of that music on the end.